Hello and welcome to this Ellis Whitton webinar, which is going to give an overview as to what schools should do if a safeguarding allegation is made against a member of staff, and it's going to be useful for anyone who works within a school environment. In this context, we're talking about safeguarding, meaning keeping children safe from harm in the school environment, and these are the things that we'll cover. Your legal obligations and responsibilities as an employer, how concerns should be raised if a safeguarding incident occurs, your duty of care towards your employees, how to deal with resignations when a safeguarding concern is raised, and what kind of records should be kept, as well as how to deal with requests for references, referrals to the statutory bodies, and any lessons to be learnt. So we're going to be having a look at how you should manage allegations that might indicate that a person poses a risk of harm to a child if they continue to work in regular or close contact with children in their present position or capacity. Schools are encouraged to have an attitude of, it could happen here. Examples of harm in the school environment can include emotional abuse of a child, for example, calling them names, ostracising them, or belittling them in class. It could include physical abuse, for example, unnecessary bodily contact, slapping a child, pinching them, throwing things at them. It could include sexual abuse, for example, involving children in looking up or in producing sexual images or grooming a child. It could include neglect, for example, failing to ensure adequate supervision or not taking care to ensure they have the right level of treatment. The legal obligations that an employer owes to employees as well as to the children that they care for are set out in a range of documents. All schools, whether academies, free schools, local authority maintained schools, independent schools, maintained nursery schools or pupil referral units must follow the duties set out in these documents. The key one is keeping children safe in education. Here I'm referring to the 2016 version, but be aware that this is regularly updated. Part 4, it deals with allegations of abuse made against teachers and other staff. Other documents include working together to safeguard children, what to do if you're worried a child has been abused, advice for practitioners, as well as the Teacher Standards 2012. And that makes it clear that teachers and head teachers should safeguard children's well-being and maintain public trust in the teaching profession as part of their professional duties. So in terms of the responsibilities, key point to remember is that safeguarding and promoting the welfare of children is everyone's responsibility. It is not something that is delegated to one person. So a child-centred approach means that everyone should consider at all times what is in the best interests of the child. That's a very useful point to remember when you're dealing with a safeguarding query. Go back to that principle. What is in the best interest of the child here? It's very important that everyone is reminded of this principle. So ask yourself the following questions. Have all your governors or proprietors or management committees as appropriate to your organisation been made aware of and read keeping children safe in education? Have all staff read at least part 1 of keeping children safe in education? Are mechanisms in place to assist staff to understand and discharge their roles and responsibilities as they're set out in keeping children safe in education? Have you considered your induction? Does that cover a clear explanation of your child protection policy, your code of conduct, which all schools should have, the role of the designated safeguarding lead officer, and copies of all relevant policies and procedures? Do all staff know who is the designated safeguarding lead? And do they understand the role of the DSL? Is support provided to your staff so that they can carry out safeguarding duties? including giving them adequate time to complete these, particularly for your safeguarding lead officers. And do staff understand their role, that the DSL will liaise closely with other services, such as social services, and in particular the local authority designated safeguarding lead officer. So have a look through, check your training, your induction, your policies and procedures to make sure that they're all consistent with this principal duty to make sure that the interests of the child are protected. So what to do if somebody has a concern about a colleague and it's a safeguarding concern? Well, first of all, refer the matter to the head teacher, principal, chair of governor or proprietor as appropriate for your organisation. Keeping children safe in education states that any concerns about a member of staff should be referred to the head teacher or principal. If the concern is actually about the head teacher or principal, then they should refer to the chair of governors or chair of the management committee as appropriate. The head teacher, or whoever is the appropriate person, will be then the case manager. If the head teacher is also the proprietor of the school, then you should refer the matter directly to the designated safeguarding lead officer at the local authority. Staff can also discuss concerns with their DSL and can make the referral by the DSL. The question to consider is what harm has resulted or may result in that child's being subjected to that particular behaviour. If in doubt, if you're not sure that it is a safeguarding concern, then make sure that you err on the side of caution and refer to LADO. So LADO will then discuss with the DSL or whoever is the referring manager the concerns and decide whether police involvement should be undertaken. They will discuss any other further steps that need to be taken, and normally it will be LADO who call the police and make the referral. It is important that you don't interfere with any police investigation. If the police are not involved, then LADO will make that clear. So the initial sharing of information is with LADO, and you're telling them about the nature of your concerns, the allegation that has been raised, the context in which it's been risen, and any other relevant information. So it is LADO who will determine whether further investigations are required internally only, or whether there should be an external referral to the police or social services. They may convene a strategy meeting in more complex cases, and then they will agree next steps with you. It is really important, though, that you don't carry out any internal investigation until LADO have been informed. The referral must always be made first. So just to reiterate, don't start your investigations until you've informed LADO. So let's consider what are the next steps once you've made the referral. Well, it could be that no further action is required, in which case you just need to record both the decision and the justification and agree what information shall be put in writing to the accused employee and by whom. LADO will also keep a copy of this. If there is no further safeguarding issue, then it's for the head teacher to determine what are the next steps in respect of any disciplinary action. If further investigation is required, then you would normally inform the accused at that stage. Notice this as soon as possible after consulting with LADO and not before. However, if a strategy discussion is needed, or the police or social services are involved, then the case manager shouldn't disclose information until those agencies have been consulted and they've agreed what information can be disclosed to the accused. Once agreed by the strategy meeting, you can then inform the accused employee of the allegations against them. You may want to consider suspension. However, you need to be careful that you do consider all options before suspending the employee, and this is because suspension must not be a knee-jerk reaction. So Are there any alternative arrangements that can be put in place, such as moving them to another area of the school, or is suspension your only option? If police or social service investigation isn't required, then discuss with LADO the next steps, and they will be able to assist you in terms of how to conduct your investigation. So what kind of potential outcomes could you be looking at? It may be, even after further investigations, you determine that there is no further action to be taken, in which case you just need to record that. For less serious safeguarding issues, you could be looking at issuing the employee with a first written warning. In more serious situations, then it could be a first and final written warning. In very serious cases where the allegation amounts to potential gross misconduct, then you could be looking at dismissal. In all of these situations, it is important that the school follows the disciplinary procedure that you have and that you afford the employee their due rights under the process, which includes the right to be accompanied, as well as giving them copies of the evidence that you intend to rely on, and you hold a proper disciplinary hearing. There are no shortcuts to be taken in this kind of situation. So in terms of your duty of care, remember that as an employer, the school owes a duty of care to all employees, and that means ensuring that they are provided support, they are providing the accused person with the appropriate level of support. So if they are suspended, they should be given a named contact at the school. And support can include advising the employee to contact their union or a colleague for support, and giving them a named contact is helpful. You may also want to provide them with access to welfare counselling or medical advice, particularly if the teacher or the colleague who has been accused is exhibiting signs of stress or you're concerned about their mental well-being. Allegations should be dealt with very quickly. That's in the interest of both the child and the person who is accused. It may help a school to get in an external consultant who can do the investigation for you. Make sure that they know what they're doing and that they act in a timely manner. Other support could include a named representative to keep the accused informed of progress and to identify any further support that they may need. Don't prevent social contact for the accused unless that could be prejudicial to the investigation. And inform parents or carers of the child as soon as possible, but only after consultation with LADO. Remember that the employee will have the right to be represented at the through the disciplinary process by a colleague or an accredited trade union official. Parents should be kept informed throughout and informed of the outcome if there is no criminal prosecution. However, they shouldn't be told about the deliberations of the disciplinary hearing or any information taken into account in reaching a decision, but they can be told the outcome in confidence. We're now going to consider the issue of confidentiality. It's important that you make parents and carers aware of the requirement to maintain confidentiality about any allegations made against teachers or other staff whilst investigations are ongoing. The Education Act 2002 introduced reporting restrictions which prevent the publication of any material that may lead to the identification of a teacher who's been accused by a pupil or on behalf of a pupil from the same school. And these reporting restrictions will continue to apply until they're charged with an offence. The restrictions will cease to apply if the individual waives their right to anonymity. Publication has a very wide meaning in this context. It includes any speech, writing, relevant programme or other communications in whatever form which is addressed to the public at large or any sections of the public. So it clearly covers comments made in emails, on Facebook, Twitter, announcements on the school's website, in assembly, at staff meetings, and so on. So great care needs to be uh, maintained here, that only those who need to know are kept abreast of what is happening. A breach of this is a serious matter because it can lead to criminal prosecution for contempt of court. If you're faced with a teacher who is resigning because of serious safeguarding concerns, which is quite often the case, it is important that you realise that the matter still has to be investigated and the employee given opportunity to answer allegations and make representations. If they refuse, you must still continue with the process in terms of recording the allegation and going through the supporting evidence and keeping a record of it. You would then need to reach a judgment about whether the allegation can be substantiated, even if a conclusion cannot be made or a sanction applied. So continue with the process, keep an accurate record, and then make your decision. A referral to the disclosure and the barring service must be made if the criteria are met. Your legal duty is to refer to the DBS anyone who has harmed or poses a risk of harm to a child, and your investigations should give you a steer as to whether you do need to refer the matter to the DBS or not. If in doubt, speak to LADO. It is very important that you don't enter into a settlement agreement to avoid processing the allegations in this kind of situation. That will be seen as an attempt to hide what has happened. So it is never appropriate to enter into a settlement agreement if a person resigns in these circumstances. As always, it's important to keep a record, but it does need to be an accurate record. So make sure that any malicious allegations are removed from the personnel files of that employee. You'll need to record all other allegations and make sure that there is a clear and comprehensive summary of the allegation on the file, the details of who it was that followed up and resolved the situation, and a note of any action taken and decisions reached. This will be kept in confidence on the employee's personal file, and a copy can be provided to the accused as well. In terms of how long you keep such records, then it's quite a substantial period of time. They're kept until the employee reaches pensionable age or for 10 years, whichever is the longer period. If the employee leaves, then you need to be mindful of your obligations. Don't include false, malicious, or unsubstantiated allegations in references. Otherwise, you do have a duty to disclose the allegations that were raised. If an allegation is substantiated and the person is dismissed, or you cease to use their services, or they resign, then LADO should discuss with the case manager and HR whether to make a referral to the disclosure and barring service for consideration of whether inclusion on the barred list is required. They should also consider whether referrals should be made to the National College for Teaching and Leadership to consider a prohibition to prevent that person from continuing to teach. So once the safeguarding matter has been dealt with, it's important to consider, are there any lessons that we've learnt from this incident? Review how the process went with LADO, whether there was a timely and accurate referral to LADO, and whether LADO's advice was followed. Discuss with LADO if there are any further improvements that you should make, and they may make recommendations in terms of improvements to your own policies, procedures or practices. And think, what could be done differently next time? What have we learnt from this particular matter? Then make those changes and monitor the situation. So to summarise, we've looked at the importance of raising awareness about safeguarding amongst all staff. It is not something which is delegated to one individual, although clearly the head teacher, chair of governors and the designated safeguarding lead will take the main responsibility in terms of following process here. but it's very much making sure that safeguarding is everyone's concern so they know what process to follow if they have a concern which arises about a colleague. It's important to remember as an employer your duty of care towards not only your children that you look after, but also all your members of staff. And that will include making sure that they are given adequate support and appropriate support during any safeguarding investigation. In terms of referrals, it is crucial that the referral is made to LADO, as we've discussed, straight away, and that the investigation is not started until that referral has been made. Be guided by LADO in terms of referrals to other statutory bodies and the police. It is only after you've referred the matter to LADO and they advise you on the next step, do you let the accused employee know and undertake investigations with them. The investigation is not started at the beginning, only after the referral. And then finally, just to recap, it is everyone's responsibility to ensure that all our children are safe within schools. If you would like further support or have questions about us and our services, then please either email inquiries@elliswhittam.com, call our helpline on 0845 2268 393, or have a look at us at our website elliswhittam.com or on Twitter or social media, and we'll be happy to support you. Thank you very much for listening.